Story 1. I had a fairly simple assault trial. The facts are pretty basic. A homeless man was told to leave by security and was ushered away. The man got upset and hit the security guard. We have some cell phone footage showing this, but the key moment was unclear. It could have been argued that the security guard touched him first. The defense counsel asked the defendant a few questions, then went in front of the jury and asked him to position her where the security guard was and reenact what happened. They more or less agreed that she should be standing about an arm's length away and pointing like a typical "hey, you can exist there, but this is private property" kind of thing. She then asked, "And what did you do?" The man looked right at her and slapped her right in the mouth. It was not a gentle reenactment tap, but a fully committed attempt to knock her out. Her lip was bleeding, and she looked shocked and fully unprepared before sitting down. The prosecutor asked, "Skeleton? Any cross-examination?" Defense counsel replied briefly, "Sir, just to confirm, you hit the security guard just like that?" "Yes," he answered. "Up until that time, did the security guard ever touch you?" "No." "No further questions, Your Honor. I had not even left the courthouse parking lot before I was called back for the verdict." Story 2. Public defender in first felony trial, methamphetamine trafficking, where the entire exchange was caught on video, including my client's alleged face and his license plate as the exchange took place in his car. When arrested the next day, he still had the marked bills in his wallet. All I could argue was reasonable doubt. Probably isn't enough. He was facing 20 years because of his record. After 10 minutes, the jury returned and asked if they could see my client's teeth. On the video, he had a severe case of methamphetamine-related dental decay, but he had not testified, so the jury did not get a chance to see his teeth in person. The judge said no, the evidence was closed. They returned not guilty 5 minutes later. I spoke to the foreman afterward. He said they were fairly certain it was him, but his teeth were so distinctive they wanted to see them to be absolutely sure. I asked, "What about the license plate and marked bills?" His brow furrowed. "That actually didn't come up during deliberations. But yeah, I guess it was definitely him. Should we tell the judge?" It's too late. The trial is over." Story 3. Not a lawyer, but I do technical work for lawyers. I am going to generalize this because it is a real case. I performed data recovery analysis of a dash camera from a company vehicle involved in a very serious accident. The driver claimed to not be at fault. After recovering data from the secure digital card of the camera, I found a video of a company manager sitting at the wheel in the company garage, weeks after the accident, while the vehicle was supposed to be quarantined as evidence. He was on the phone with someone receiving instructions to manipulate the dash camera. We could hear him say, "No, I already pushed it." He had pressed the red "Record Incident Manually" button and recorded himself tampering with evidence. This was presented in pretrial negotiations. The case settled immediately in favor of my client. Story 4. Not my story, but one I heard as a young lawyer, illustrating the dangers of asking too many questions on cross-examination. The lesson is to quit while ahead and not ask open-ended questions that allow the witness a chance to explain. The case was about a vicious fight outside a bar. The accused was charged with biting the victim's nose off. The only witness was an elderly man who saw the whole incident. On direct examination, the witness said he saw the two fighting in a crowd of brawlers from across the street at night. The defense cross-examination went like this. Question: I see you are wearing glasses here in court. Are you nearsighted? Yes. Question: from the police report, it says you were not wearing your glasses that night. Yes, I ran out of my house without them when I heard the riot. Question again: from the police report, it was particularly dark and foggy that night. There was only a single light above the bar, and you were 100 feet away. Is that correct? Yes. Question: so, you admit you are nearsighted and that the visibility conditions were poor. You could not possibly have seen exactly what happened 100 feet away from you. Correct. Well, yes, but... Question: please just answer the question. Yes. And here the lawyer should have stopped. Instead, they asked the fatal question. Question: so, Given you admit you could not have seen exactly what happened, why did you testify it was my client who bit off the victim's nose? Could have been anyone fighting. Because later, your client ran right past me and spat a severed nose onto my shoe. This last detail had not been in the police report and was not mentioned on direct examination. Story 5. Do administrative proceedings count for this question? Years ago, I was working for a partner handling municipal and planning law matters. He had a client, a Hindu group originally from South India but established here in Canada, who wanted to build a community center. They were being blocked by a municipality on the flimsiest grounds. The correspondence, all on paper at that time, was unbelievably rude and dismissive of our client. Naturally, the client assumed the municipality planning office was full of racists. How else to explain their bizarre behavior? It is important to note that they had never actually met for an in-person meeting. This was all by correspondence. At the first meeting with the client, they were very angry. They wanted to launch a proceeding immediately and had already filed the paperwork before realizing they needed professional help. This would have earned our firm tens or even hundreds of thousands of dollars in fees. I was tasked with summarizing and categorizing the correspondence for the partner. A single glance at the correspondence told me what the problem was and how to solve it immediately, though it meant our firm would lose those potential fees. The group was called something like the Vedic Aryan Society. Their decorative letterhead had an ornamental border featuring swastikas. It was clear from the correspondence that the city planners had no idea who Vedic Aryans were or that they were originally from South India. They assumed these clients were neo-Nazis because of the word Aryan and the use of swastikas. Just as the clients assumed the planners were vicious racists, the planners assumed the clients were vicious racists. This led to the application being turned down on flimsy grounds and the nasty tone in the correspondence, which essentially said, "We don't want your kind in our community." A single letter carefully explaining this misunderstanding was all it took. The application was approved, and the proceeding was withdrawn. Additionally, we advised that a different choice of decorative border would avoid such issues in the future, thus preventing the dumbest possible waste of time. Story 6. This was not a trial, nor am I a lawyer, but at one point I was interning for a family law attorney. He had a divorce case in progress, and I attended client meetings and mediation with the other party. They were discussing custody and were unable to reach an agreement. I proposed a potential agreement to our client, and after the other attorney discussed it with their client, they accepted. After we left the client, I was excited about resolving the issue when the lawyer I was interning with told me that the custody schedule I proposed was identical to one that had come up earlier in the negotiation. The only reason they accepted this time was because both parties perceived me as a neutral third party, so they believed the compromise was fairer than when it had been proposed by one of them. Story 7. My uncle went to watch my father, a defense lawyer, in court on 2 occasions. Both times, my uncle was identified by a witness as the suspect. The charges were dismissed. Story 8. I had a client when I was working in the clinic at law school. She had stolen pills from a hospital, and the district attorney sent me security camera footage. It showed her about 10 feet from a camera, looking around and putting pills in her pocket. I asked my professor how to approach it, and he suggested showing her the video. I did, and her response was, "So do you think I have a case?" She ended up finding money for a private defender and fired me. She received a few years in jail. Story 9. Heard this one from a friend defending a client charged with beating a man to death with a bat. Police found him shortly after, a block away from the crime scene, holding a bat and wearing a coat, both covered in the victim's blood. He argued at trial that he was walking down the street, minding his own business, when another man offered him a free coat if he would hold his bat for a few minutes. He said he accepted the bat and put the coat on. He then proceeded to wait for the mysterious man to return when the police found him. The jury was not out long before returning a guilty verdict. Story 10. I had a client charged with illegally camping on public land, also known as being homeless in public. I moved for a dismissal at the first appearance based on lack of probable cause. The municipal code defined camping as sleeping outdoors between 9 p.m. and 7 a.m. I pointed out that the police citation showed they ticketed my client at 8:30 p.m. Story 11. A father and son got into a physical argument. Both adults. The son pressed charges for simple assault. There was plenty of evidence to acquit, as it sounded like mutual combat. The son was kind of a troublemaker and was provoking him, pushing, and so on, up until the punch that busted his lip and led to the police being called. We were ready to acquit until the father took the stand. Virtually the first thing out of his mouth was, "Oh yeah, I hooped his ass good," with plenty of detail. His lawyer and judge both visibly shook their heads. We had to convict. Story 12. Not dumb, but definitely not anticipated. I was representing a young man who was about to turn 18 and lose his Social Security benefits because, while he met the requirements as a minor, he did not meet the cognitive requirements as an adult. He was too smart. Our argument was that, although his cognitive tests showed progress, he was still unable to hold down any employment due to diagnosed post-traumatic stress disorder stemming from persistent harassment at school and a violent incident where he was mugged on school property. I had reviewed our argument and planned on his mother providing significant testimony. We had gone through the traumatic scenario several times, and he was able to describe it without problem. Because of this, I was comfortable having him testify on his own behalf in court. However, when it came time for him to recount the scenario before the administrative law judge, he completely broke down. He was inconsolable and utterly incomprehensible. We never got to his mother's testimony. I thought I had ruined his case and felt horrible for putting him in that situation. They ended up prevailing, largely because he demonstrated that even being reminded of that situation caused him to lose composure and require such support that his prospects for finding and maintaining employment were zero. Story 13. I was told this story a long time ago. Local police department had been working undercover as homeless people and were targeting muggers in the city center. The defendant was in court with a cast on his leg and crutches nearby. He had been shot by the arresting officer. The officer was on the stand giving the details of the arrest, and it went something like this. I was working undercover on the mugging task force dressed as a homeless person. The defendant produced a knife and demanded my wallet. I gave him the wallet and he fled on foot. I gave chase, identifying myself as a police officer and ordering him to halt. The defendant continued to flee, and after multiple warnings I drew my revolver, took careful aim, and disabled him, which allowed me to make the arrest. The defendant jumped up and yelled, "Your Honor, that policeman's a liar." After I took his wallet, all I heard was, "Guess who?" Bang! No idea what the outcome was. Story 14. This is more funny than anything. I am a contract attorney in the entertainment and sports world. A client who is a mid-level writer and director called me one day and asked what legally constitutes a contract. I explained the basics. There has to be an offer of terms, acceptance of terms, consideration of value, mutual agreement, capacity to make the agreement, and the offer in question has to be legal. I heard silence and then, "Shit, we may have an issue." He went on to explain that he was in Las Vegas for the week and got to talking to a guy. They were having fun, getting goofy, and the guy pitched him a story. He loved it, and long story short, he wrote it on a piece of paper the bartender had. On that date, they agreed that if he used this idea, the guy would either get 25% of the profit or a part in the project, his choice. He signed it, the guy signed it, and the bartender witnessed it. I laughed. He said, "But I love the idea. I legitimately spent the night writing it out. How messed up am I?" I asked him who took the signed paper. The guy did. I asked if they were drunk. He said he was stone cold sober. I asked if the guy was drunk. He said he never saw him drink. I said the risk factor was low but possible. He was a bit upset and asked if he could change the story and get away with it. I said that was a question for his copyright attorney. Offhand, I asked where he was when and if he knew what the bartender looked like. He gave me all that. He was going to ask his copyright lawyer as he had a good start on the idea. A few days later, I was able to track down the guy working the bar at the place he was at. The guy called me back. I explained who I was and asked if he by any chance remembered the scenario I laid out. He started laughing and responded, "Yeah, I remember those too. They were blitzed out of their minds doing bumps at my bar. That's why I came over." Then they wrote up that thing and asked me to sign it. I did. But we had to ask them to get the hell out when the guy pulled out a pipe. I asked if he knew what happened to the paper they signed. He said, "I threw that away. It was all gibberish and illegible anyway. I just pretended to sign it with a straw because it was the only way they would leave. But hey, your guy left me a 75% tip." I hung up and texted my client back that I had taken care of it. His response was praying hands and $3,000 to cover your time? The client got an option with his idea he and his bar buddy cooked up but never got produced. Story 15. Interning for a public defender. Statutory rape case. A 30-year-old defendant accused of having sex with a teenager. A paralegal gave me a recording of a phone call from the jail where the defendant was being held and asked me to transcribe it. The prosecution had just entered it into evidence. I listened to the phone call. It was the defendant calling the teenager he had been accused of having sex with from jail, telling her how much he could not wait to have sex with her once he got out of jail. He explicitly admitted to the accusations and made it clear it was not a one-time occurrence but rather a repeated event, which had been previously disputed. The case quickly turned into a plea deal. Story 16. It was a class action data breach case. We were suing a company that had accidentally emailed thousands of their customers' information to a group of scammers. Ridiculous negligence and complete disregard for even the most basic data protection measures. Due to some procedural issues, we had to prove that our class representative specifically had monetary damages as a result of the data breach. This would normally be a huge problem because actual provable damages from a data breach are extremely rare. Our class representative was unusual. He had received the standard notice of data breach and had absolutely freaked out. Panic attacks, medical problems, and he lost his job. In a rare situation, we had the opportunity to hold these people accountable for harming tens of thousands of people. The defendants obtained our representative's employee file during discovery and found he had been fired for a third strike of missing work. He had been home with a panic attack. They wanted to show he had skipped work for his daughter's school field trip, which had been his second strike. We presented an elementary school field trip schedule at a hearing, which allowed us to recover millions of dollars for the class. Story 17. I was involved in a normal paternity case where a woman had a baby and filed for paternity. The man disputed it and said he was not the father, as usual, and the court ordered the standard paternity test. The test result showed he was not the father of the baby, but surprisingly, it also excluded the mother. After a lot of discussion, we heard off the record that the mother probably borrowed someone else's baby to make a child support claim and did not understand that when a court orders a DNA test, they usually test the mother against the baby as well. Story 18. A woman worked at a missile factory producing missiles for the Air Force. She filed a false bodily injury claim from a minor car accident. She was receiving treatment from questionable medical providers who were paid from the lawsuit proceeds, which raised our suspicions. Her treatment records showed she was receiving care at the same time she was logged into the secure missile facility, monitored by a U.S. government contractor. During cross-examination, I presented both sets of records and asked her to choose which was more likely accurate: the missile factory's secure facility or the medical provider seeking payment from the lawsuit. She chose the missile factory records. She ultimately lost the case and owed my client $230,000 in legal fees, some of which her plaintiff's law firm had to cover. This outcome is not advertised. Story 19. A client facing a termination of parental rights case called me on the day of the trial to say she could not make it to court because her current boyfriend surprised her with tickets to the Caribbean. She actually told me to call her after the trial to let her know how it went. Spoiler alert: it did not go well. Story 20. I was on a jury once for a road rage incident. The man was driving a truck and forced a young girl in a car to hit a barrier wall. The defense attorney tried to portray the girl as an addict and was very belittling to her on the stand. This made us sympathetic to her, not the other way around. There were also witnesses who all basically said the same thing. The man was at fault. The only thing we did not find him guilty of was the damage to the vehicle because the prosecutor never presented or showed proof of the damages to the car, only that it was totaled. Story 21. Not a lawyer, but one of my employees' stories. He went out on disability for a sore back. This happened often in the union come springtime. Guys would say they were going to visit Dr. Summeroff. He was also an urchin diver, and when the company sent someone to verify he was not abusing the system, they took photos and videos of him entering and exiting the water in full scuba gear. The company took him to court, and his defense was that they could not prove it was not his twin brother. The case was dismissed, and he returned to work in the fall. Story 22. Saw a lawyer argue a case as follows. Judge: how does your client plead? Lawyer: not guilty, Your Honor. Judge: on what grounds? Lawyer: the description of the suspect in the police report mentions the suspect having one leg, Your Honor. Judge, ruffling through papers: yes, I see that written here. Lawyer: well, my client has two legs, Your Honor. Judge, visibly baffled. Case dismissed. To answer some questions, this was not during a formal trial. This occurred in a lower-level court, the court that handles parking tickets and public intoxication charges, where the stakes were lower and most people did not have attorneys. As a result, many usual court formalities were set aside to make things easier and more efficient. I am aware that in a formal trial this would never happen, but here I doubt more discovery was done beyond reading the police report. Story 23. I'm not an attorney. I was a pre-law student before switching to engineering in my junior year. Now I have a master's degree in planning and a master of legal studies in land use and environmental law, so I am familiar. But I was sued for getting rear-ended. Yes, you read that correctly. I braked suddenly to avoid a deer, and a man rear-ended me. He had recently undergone a spinal fusion in his neck, and his airbag damaged the hardware, so he saw it as an opportunity for a payday. When the responding officer arrived, and the man who hit me flashed his badge, I realized I would not get fair treatment. I did not. The officer did not write him a ticket but gave me a ticket for reckless driving and coming to a sudden stop without adequate signal. My insurance company offered to settle with him for $20,000, but he refused. So I went to a deposition. The deposition went well, and my insurance company made another offer of $60,000. Again, his ambulance-chasing lawyer, who advertised widely, said no and demanded $500,000. The court date was set. It was going to be a bench trial, as that is how my state handles some of these cases. I managed to get both tickets dismissed representing myself and thought that would be the end and that he would finally settle. No, he pressed on. My attorney was provided by the insurance company. I had moved away, so they flew me back and forth for the deposition and court date. In court, my attorney called the responding officer to the stand and asked one question. Lawyer: were the brake lights on the defendant's vehicle operational? Officer: yes, they were. Lawyer: that is all, Your Honor. The plaintiff's attorney stood to speak, but the judge stopped him immediately and said, no, stop right there. Don't waste your breath. This matter is dismissed with prejudice. My trial lasted 15 minutes. The man could have accepted a $60,000 settlement from my insurance company, but instead got nothing and had to pay his attorney. A dishonest or honest slip from a police officer on the stand might have saved me. Even better, since he lost and never took the settlement offers, my insurance rates never went up. My insurance company said they would pursue him to recover their expenses. I assume they did. Story 24. I don't have a great story of my own yet, so I'll share one from one of my bosses. We represented an event company that was hosting a hot air balloon show on behalf of a city that had been dismissed from the case due to sovereign immunity. The plaintiff was a volunteer who signed up through the city's program, so he had not signed a waiver with our company and was not supposed to help with the hot air balloon activities. Volunteers were supposed to do things like setting up booths and arranging chairs. The plaintiff came over to the balloon area, asked if they needed help, and was told he could help hold a rope while the balloon was being raised. The rope needed to be loose during the raising process and then tied down afterward. The plaintiff was told to put on gloves, but he did not, and was strictly instructed not to wrap the rope around his hand, which he did anyway. The balloon jerked unexpectedly and tore the skin off part of his hand. Fortunately, he only had about $6,000 in medical bills because the injury was not very serious. He did not lose a finger or tear a tendon, just the skin. In our jurisdiction, 95% of personal injury cases are valued by multiplying medical expenses by about 1.5 to 3 to account for pain and suffering, with most settling within that range. Given the nature of the injury, we placed the value at 3 to 5 times the medical bills, between $18,000 and $30,000. This represents an expected jury verdict range, so settlement offers tend to be lower early on to save time and expenses from going to trial. We offered $12,000 before trial, but the offer was rejected. The plaintiff was still demanding $250,000. We probably could have negotiated up to around $20,000 for our client if negotiations had been pursued, but they did not. At trial, the plaintiff portrayed the injury as the worst imaginable and claimed lifelong trauma and inability to cope with his scarred hand. After a lengthy exchange between the plaintiff and his attorney describing how disfigured the hand was and how he now wore a glove to hide it, the attorney dramatically paused, turned to the jury and said, "Well, show it to them." The plaintiff removed the glove and extended his hand to the jury. The jury leaned in, squinted, looked at the attorney, back at the hand, and then leaned back with looks of confusion because there was barely a scar. The verdict was awarded for the medical bills only, down to the penny. The initial photos were quite gruesome, showing skin missing from half the hand with blood everywhere. These were admitted into evidence, and the jury reacted to them. However, by exaggerating the lifelong emotional distress from the supposedly permanent disfigurement, the plaintiff lost sympathy. If it had been me, I would have had the plaintiff admit that he is okay now and grateful for that, but he deserves compensation for the ordeal and the significant pain he endured during recovery. But oh well. Story 25. The company was not performing well, so the venture capital plaintiff sued the entrepreneur, claiming that the defendant had not revealed key information and risks. This occurred shortly after the Theranos case, so presumably, the plaintiff believed he could use a similar strategy as the misled investor. There was substantial evidence that these risks had been disclosed. The key point was that meeting minutes, which the venture capital plaintiff himself had edited for clarity, showed they had discussed this key risk, and he invested after that discussion. It appears he had not disclosed this information to his attorney. Story 26. Not me, but a lawyer told me that when a witness testified that her client was wearing a mask during an armed robbery, he shouted across the court, "She is lying. I was not even wearing a mask on that job." Story 27. Well, I am not a lawyer, but my brother-in-law got away with a driving under the influence charge. He crashed his mother's truck into a fence along the side of the road. He got out and started vomiting on the side of the road. The owners of the fence heard the noise, then saw what was happening and called the police. The police arrived and arrested him for driving under the influence, but did not read him his rights. They also never saw him driving, nor did the witnesses. His lawyer argued there was no proof he was the driver, and his testimony was dismissed because he was never read his Miranda rights. The whole case was dismissed to his advantage. Unfortunately for him, he picked up another driving under the influence charge that was upheld while he was going through the legal process of the first one. He was not given leniency in his sentencing. Story 28. Not a lawyer, but my brother is. Typically, jurors do not learn whether the defendant has a criminal record because it could bias the case. However, during jury selection, the judge often asks the jurors if they have any criminal records. If they do, they would not be selected to serve as jurors. During jury selection, the judge asked the room to raise their hands if they had a criminal record or criminal experience. My brother's client raised his hand. After the trial ended with a guilty verdict, the jurors asked my brother to tell the client that they thought he was the most honest witness of all those in the case. Story 29. While shadowing a lawyer on a pro bono case as part of my studies, I sat down with him and his client before the trial. The case involved the client allegedly dealing drugs to minors. The lawyer told the client repeatedly, "When you don't have to answer, don't answer. Do not talk about anything regarding dealing drugs. When not spoken to directly, do not even think about opening your mouth and saying anything." 10 minutes into the trial, the judge said something along the lines of, "The defendant is accused of dealing drugs." And the client immediately responded, "Yes, I did it, but I don't do it anymore." The trial ended shortly afterward. Story 30. My friend's employer lost a significant case involving injury on a construction site because their lawyers did not show up. Story 31. No one noticed that the date stamp on our expert's video of the fire scene did not match the date he said he was there investigating. Story 32. Of course, I am not a lawyer, but we took our former landlord to small claims court. When we moved out into our recently purchased house a few days before our lease was up, the landlord came in and cleaned the apartment while we still had a few days left on the rental. The plan was to go back and clean it before the lease ended. However, a day before the lease expired, we received a statement from the landlord keeping our entire security deposit to clean the apartment. On the last day of our lease, the apartment was cleaned by the landlord. We did not have to do it. Since they cleaned it prior to the end of the lease, when we vacated, the apartment was clean. We were prepared to argue that since the landlord already cleaned it, the apartment was clean at the end of the lease and we should not have to pay for cleaning. In small claims court, before we even presented the argument, the judge reviewed the contract and found no provision allowing the landlord to charge for cleaning. We won, though not for the reason we expected. We received the money. I learned that in small claims court, there is no provision to enforce the judgment. If the losing party does not pay, you must go to regular court to obtain a judgment and enforcement mechanism, such as placing a lien on the property. Although the amounts for small claims court have increased over the years, few cases are taken there. Regarding judgment and enforcement, if a judgment is issued in your favor, the court can order the losing party to pay, but you may need to take additional steps to enforce the judgment if the other party does not comply. Story 33. One of my first public defender cases involved representing a sweet, tiny 4-foot 10-inch woman charged with felony criminal destruction of property. She gave typical "it wasn't me" excuses, but as a novice, I fully believed her. At the pretrial conference with the prosecutor, I told him we were taking the case to trial. He laughed. I should have known. On the way out the door, he said, "Oh, I almost forgot. Do you want the video? I have it here and can transfer it to you on a USB to avoid discovery." Looking at my client, I asked, "Video?" We watched it together. My client was wearing the same dress she wore to court. We did not go to trial. I got her 7 months in county and a downgrade to a misdemeanor. She served only 3 months because she found out she was pregnant and received early release. She was an awesome person who made an emotional mistake. I truly hope she is doing better. For what it's worth, I never saw her name in the client pool again, unlike several of my repeat clients. Story 34. This is not a story about winning a case, but about getting a client to hire me. A potential client called for estate planning help and wanted to speak directly to me because he had never hired an attorney before. He wanted to ask a few questions and get a sense of the approach. He was honest and said he planned to shop around before choosing an attorney. We were chatting briefly, and the conversation went like this. Client: I was wondering if there's a way with a will to achieve certain goals. Me: Client: well, I'm sure there's a way to do it, but are you able to do that? Me: where there's a will, there's a way. Finger guns in my office by myself. Client: aha, okay, I'll hire you. Who knew a joke that dumb would do the trick? My kind of client. Story 35. I have always loved the case of the man accused of stealing a Miami Dolphins jersey and wearing it to court. Story 36. I served on a jury once, and the prosecutor thanked the jury as we left the courthouse for not convicting. The defendant would have been a 3-time offender and sent away for an extended stay. He was set up by police officers in Yonkers, New York. He was accused of robbing some cars and resisting arrest, which resulted in one of the officers being on disability for the previous 6 months. He ingested angel dust to hide his drug possession during the arrest, but he never broke into a car. He was a big man, about 6 feet 4 inches tall and 350 pounds. His description of the experience of the angel dust moving from his stomach to his bloodstream while under arrest was hilarious when he took the stand. His defense attorney did a great job showing camera stills from adjoining businesses and argued it was a setup. Photographs proved he never entered a car. It was obviously a targeted arrest by the police officers who just wanted to arrest this man for anything. I lived a few towns away and knew the reputation of the Yonkers police. It took me a while, but I won in the jury room that day. Not guilty. By the way, the county never sent me my jury pay. Story 37. A few years ago, I was managing an authorized Apple service provider. We were a third-party company authorized by Apple to repair customer computers on Apple's behalf. This was common in my country because there were no Apple stores, only retailers. A lady came in claiming we had switched her motherboard without her consent and erased the serial number, which is technically impossible. Only serial number writing was possible on new parts, at least at that time. The issue with her computer was caused by a technician's mistake while handling the device. We purchased a new motherboard from Apple, and the technician forgot to serialize it. When the customer checked for the serial number, it was missing. We informed her of the mistake and asked her to bring the computer back so we could properly serialize it. She refused, saying we would make it worse. A few weeks later, we received a call from the Customer Protection Bureau in my country. They found nothing wrong with how we handled the issue, but the lady remained angry and did not accept their suggestion. I thought the matter was over. 2 weeks later, we received a court notification that the lady was suing us for damages and theft of property. I read the citation papers before contacting our lawyer. I noticed the documents incorrectly listed the original serial number. For example, the original number was M7XXXX7D, but her lawyer was suing over the computer with serial number M7VWW00TD. I informed our lawyer so we could proceed with a conciliation process in court. There were many questions about the serial number on the court papers, but none regarding the serial number on the service order. After about 30 minutes of denying we ever had that computer, our lawyer said, "We will countersue for defamation because this computer was never in our client's possession, and we will use Apple's system to support that." The lady and her lawyer were furious when the serial number did not appear in the searches. The judge dismissed the allegations and they left. I believe they never realized the whole issue was due to their typo. The best solution for the lady would have been to accept our offer to serialize the motherboard, as it was brand new, and move on. Instead, she spent an unknown amount of money on this unnecessary dispute. Story 38. I am not a lawyer, but the person who had his driver's license revoked and then appeared in the trial using a video call was not only obviously driving but also mentioned it as if it were obvious before realizing how serious the situation was. That case must be one of the most foolish actions a person has taken in a trial. It certainly caused the lawyer to leave the courtroom as soon as possible. Story 39. Back in the day, I used to do a lot of 50H hearing coverage work for the New York City Metropolitan Transportation Authority. Basically, it is a deposition that occurs before a lawsuit is filed as a procedural way for the city to gauge the merit before suit. This day, it was a bus accident case, and the person was claiming that they could not do anything because of severe pain all over, specifically in their back. Unfortunately, they showed up with their morbidly obese husband and complained before we started about how annoying it was to have to physically lift him in and out of his chair every time he needed to get up. I looked at their attorney, and I could see him mentally collapse before my eyes. Story 40. One time, the opposing side's lawyer told the judge that he had not read the case. Story 41. The opposing counsel's client was accused of fraud and was so scared of being caught the first time that they forged another email to disprove the fraud. The second email made the case stronger. Story 42. Not me, but my mom, who represented a school district trying to fire a teacher for physically abusing a student by hitting their knuckles with a ruler for misbehaving. The defense argued that the teacher was from a different generation where that sort of punishment was common, and that this made it acceptable to ignore the law and abuse children. When asked for a rebuttal, my mom's team's lead attorney said, "We rest our case. They won and the teacher was fired." Story 43. Let us just say that when my client on the stand said of the plaintiff, "I hate that man," things definitely took a turn for the worse. Story 44. Not a lawyer, but a friend's cousin who is one was asked how she could defend obviously guilty people. She said it was her job. One case that comes to mind involved a man reported to have beaten another man with a stick or something heavier. She asked the witnesses, "How did you see the accused hold the stick?" They all held up their right hand in an aggressive manner. She then said, "But my client is left-handed." That was enough to get him acquitted. She treated it like a game. Story 45. The juror told me my victim did not sound sufficiently scared on his emergency call. Story 46. I'm not a lawyer, but I have a story about my parents' divorce. My father lost everything, as expected in the late 1970s and 1980s. He packed what he could fit in his car and left. My mother got everything: the house, car, and kids. She wanted the divorce. There was no abuse, no cheating. She just wanted out and kept everything, like winning the lottery. My father paid my mother child support and alimony. The alimony lasted until my father started getting the alimony checks back from the bank with my mother's new boyfriend's signature on them. It seems she would sign over the alimony checks to her boyfriend to cash. My father took her back to court. The judge basically said, if you are close enough to this man to sign over checks to him, then you are close enough for him to take care of you and the kids. Alimony was terminated. Even my mother's lawyer told her that was a stupid thing to do. Story 47. Client on trial for prostitution required a Vietnamese interpreter. When it was time for the police officer to identify the defendant, he pointed directly at the interpreter. The motion to dismiss was instantly granted. Story 48. Not a lawyer but the defendant and victim. This was when I was still in high school and things like autism, behavioral disorders, and individualized education programs were still being developed. Due to a culmination of many kinds of stress, I had a bit of a meltdown. My individualized education program stated that the school was supposed to get me to remove myself from the situation, go for a walk, and calm down. Instead, they grabbed me, manhandled me, shoved me into a windowless staff room, and locked the door behind me. In an effort to vent some of that anger, I made an unwise choice to pick up a plastic chair and throw it at the wall. That was when the school's resource officer, who considered himself very important, rushed into the room, which I was alone in, and grabbed me from behind. I, being very angry and not knowing who was grabbing me, writhed and tried to shake off whoever it was. The resource officer then filed assault charges against me, intending to ensure I ended up in juvenile detention. I was suspended from school for over a month leading up to the trial date. When we got there, the judge, a very professional woman, had this exchange. "So did you all follow anything in his individualized education program on how to manage that situation?" "No, but," interrupting the resource officer and looking at me, she said, "We are going to do what is called a continuance. If you keep your nose clean for 6 months." Young man, this never happened. After that, I was moved to a different setting in the school, could do all my work online at my own pace, thrived, and never had a single issue for the rest of my time there. In summary, the school resource officer assaulted me from behind during an autistic episode and tried to blame me. The school was forced to tell the judge that they caused the situation by ignoring all the rules for dealing with me that they had agreed to and made every wrong decision. The judge professionally called them out and dropped the charge. Story 49. The other party was hiding assets, said they could not work, and refused to disclose their address. We had an inkling of where they might be. We looked on Google Street View in a rural area, and a Google car happened to be taking updated photos at the right time, showing them at the address with the hidden assets and undertaking work. You cannot opt out of a digital life. Story 50. A car pulled too far into an intersection and then backed into me at about 2 miles per hour. There was no damage. I got out and asked if they were okay. They said they were fine and we exchanged information. Later, they hired a lawyer and sued for just under the amount required for a jury trial. The whole situation involved dishonest doctors and physical therapists. Despite zero damage, they claimed they were unable to function. The insurance company provided a lawyer. We both testified. The judge ruled in their favor because he believed I would not have asked if they were okay if the accident had happened my way. Story 51. I had a defendant on the stand at a bind-over hearing similar to a grand jury hearing. The defendant wanted to testify over the vigorous objection of his public defender. My detective had testified that the defendant was in a barbershop when arrested, sitting in the barber's chair with a suitcase full of lysergic acid diethylamide. Under the chair, The defendant took the stand and testified that the detective was lying because the suitcase was not on the floor but in his lap. The defense attorney's head hit the desk. The judge bound him over, and the detective immediately asked the court reporter for a transcript. Never underestimate the stupidity of criminals. Story 52. One of the states I practice in has borderline crimes. If your criminal history aligns with the severity of the felony and falls within a certain range, you are either presumptive prison, presumptive probation, or in the gray area in between, known as the border box on the grid. When marijuana was illegal everywhere, a judge in a district where I used to live had his own rule for border box drug offenders. If you tested positive on a urinalysis test, you went to prison. If clean, you were allowed to go home. He explained this to a defendant, who then went back to take his test. About 10 minutes later, the bailiff returned and announced, "Your Honor." The defendant refused the urinalysis but admitted he smoked marijuana in the parking lot before coming inside. The judge brought him back in and asked what he was thinking. The man simply said, "I was nervous for court." Story 53. Not applicable, but watched it in court about 20 years ago. This was before local law enforcement had digital cameras and very sparingly used their 35mm cameras. It was also when marijuana was illegal. A local motel had called the police for marijuana use in a room. The motel had legitimately attempted to handle it themselves by telling the defendant to stop or be forced to leave, but the defendant refused and proceeded to yell at the motel staff member. So the police were called. Police arrived. The defendant continued to act foolishly, was booted out by the motel staff while the police waited, acted more stupidly, and was ultimately arrested and charged with paraphernalia possession when a wooden marijuana dugout was found in the motel room. The defendant apparently refused to take a plea deal and it went to bench trial. The defense's argument was that it was not a dugout, and even if it was, it must have belonged to a previous guest. Again, this was before digital cameras, and the police had initially entered the dugout into evidence storage without taking any photos of it. The brand new public defender made a huge error by never asking to see the dugout up close prior to trial. The dugout was entered as evidence in trial. As the prosecution pointed out, neatly carved onto the wooden dugout was defendant's initials, S freaking dugout. Needless to say, the judge found him guilty when it was spelled out that it was a dugout and it was the defendant's. The story does not stop there. The defendant decided to have his sentence immediately instead of later. The judge gave him time served and a small fine. Instead of remaining quiet, the defendant blurted out and demanded the judge return his dugout because it would be double jeopardy if he was charged again for having it. The judge was very amused by the request, but not favorably for the defendant. Thanks a bunch for sticking around till the end of the video. Remember to subscribe, and until next time, stay awesome and goodbye.